A warm welcome. Thank you for joining us today for our seminar. I hope that this will be a productive and engaging session. It's scheduled to run for approximately an hour. Perhaps we'll go over a little bit by about 15 minutes. My name's Helen Thompson and I head up the Contentious Trust and Probate team here at Myerson. I'm joined by Eleanor Clark, Senior Associate, who will be talking to you about wills, when they go wrong, and associated issues with the Inheritance Act and will validity disputes. Rhiannon Edwards, Senior Associate, will follow, and she'll be talking about executive issues, managing conflict and misconduct. If you're here in person, please come and see us following the presentation with any questions that you may have. We'll be staying around later to discuss any points that you might want to raise. And for those of you that are joining us online via Zoom, please do use the Q&A facility and we will follow up with any responses after the seminar. Just as regards a quick bit of housekeeping, for those of us that are here today, please ensure that your phones are on silent. We're not expecting a fire drill, so if the fire alarm does sound, please remain calm. The fire exit is located at the back of the room and will guide you out safely. So without further ado, probate litigation, unlocking the potential and seeking to further this area of practice. So for those of you involved in this area, you'll be aware that probate litigation has become one of the fastest growing areas of legal practice today in England and Wales. And my presentation is going to look at the historical context and key factors driving this growth and recent legal developments in this field. It is inescapable to overlook the fact that probate litigation and this sector has increased phenomenally. As the slide shows, there's been a significant increase in the period between 2012 and 2013 for Inheritance Act claims alone, up to 127%. With that has become the increase in firms operating in this field. Today we have at least 300 specialist firms operating solely in wills and associated disputes. And previously, for those who've been in practice as long as I have, you might have found that probate litigation was snuck in either in a wider dispute resolution team or alternatively in a wills and probate team. But it's very different today. The internet has furthered that, and we have a 60% increase and growth in searches as against disputing a will, and you can see the statistics set out there. A couple of points just to mention that aren't on the slide, and it may be something that those of you in private practice are interested in, but looking at the data for those people that do not have a will, you might be surprised to know that that's around 56% in England and Wales. So they don't have a will. Those that do tend to be over their 55 age mark. STEP, equally, was founded in 1991, and ACTAPS followed soon in 1997. And those particular foundations have also highlighted the growth in this particular area. So consistent with the growth in this sector is the growth of the probate litigation team, and here we are in all our glory. When I joined, the team comprised of 2 people, myself included, and that was back in 2016. And I'm a litigator by practice, so my background starts with disputes, but I specialised in the last sort of 15 to 20 years solely in this particular field. And you can see us from partners to apprentices there. Some of the key features about our team: we're one of the largest in the Northwest. We're ranked as Tier 1 in the Legal 500, and all our solicitors are either ACTAPS members or qualified or STEP accredited. We deal exclusively with contentious probate matters. We don't dabble. We deal with all sorts, ranging from 75 Act claims as claimant and defendant. We also deal with validity matters, again for claimant and defendant, and all sorts of trust and probate disputes that you will be aware of as well. For those of you that don't know, we're all based in one office here in Altrincham. We're a full service firm, and we do have a good rapport with our other teams, including our private team and other sectors who we commonly swap ideas and discussions about and also assist with. So where are we today? We have, as we know, old laws effectively in modern times. It's actually quite hard to believe that we are in a world of online and digital presence, yet we are still using legislation that is so old. The Wills Act 1837, which many of you will be familiar and know about, is 188 years of age. Only slight adaptations have been made to this Act throughout its life. They've been needed to reflect modern legal and social development, such as the COVID regulations, which were a necessary part of that process. The Inheritance Act 1975, it has its 50th birthday this year. Ellie will be talking to you a little bit more about the implications of the Act in more detail, but it's hard to think that we're still using an Act that, as I say, is as old as it is. You might be interested to know that the first case that went through the courts, and the first 75 Act, was Re Coventry back in 1980. That, together with the Illit and Blue Cross case, which was the first one to reach the Supreme Court, became the hallmark, really, of cases that were moving forward to allow the courts to achieve more fairness, move away from a quite rigid approach, particularly in family and financial matters. The question we might all want to ask ourselves today, however, is where we're going to be in the future. I would suggest that we're not going to be waiting 188 years or indeed 50 years for the pace of change to move any slower. It's going to take effect quite quickly. And I think AI and social changes will be the driving factor. It's how firms are prepared to cope with that and put systems in place to protect their business. So why are will disputes increasing? I've chosen only 4, and I'm sure you can all think of different things that have affected you when you've been dealing with work of this nature. I would suggest that blended families are a significant factor as to these types of disputes. Divorce rates have increased since the 1970s, and more complex family structures arise with multiple potential beneficiaries. It wouldn't be uncommon, for example, to find first, second, or even third marriages, and they do create a melting pot of issues with people pulling in different directions for different reasons. An ageing population also contributes to certain factors as well. The issues that we have here are increasing wealth as a result of people living longer and their income being tied up. But an ageing population also brings with it some of the horrible issues that we do know about in relation to aspects of dementia, and they point to issues in relation to capacity. Again, an area that contentious probate litigators look at a lot. Increased wealth, I've included that because rising property values have increased. You can see the statistics there, 55% in 1975, up to 65% in 2025, and there's a trend going further upwards as people look to buy their own properties. A bit different to the European partners, where they are quite keen and happy to rent. We talk a lot about the cost of living crisis for different reasons, and the cost of living crisis is something that places pressure on individuals to perhaps make changes and look for income streams that perhaps they wouldn't have done before. It used to be the case that wills were considered sacred. That's not the situation anymore. There's much more of a sense of entitlement, and people are really willing to challenge things that they consider to be genuinely unfair. One of my colleagues mentioned to me yesterday that she perceived we are living in an inheritocracy, and I think she's probably right. We do have others as well that we can turn to and look. It's not just the individuals that we meet in our daily lives. We've got celebrities who also experience issues, and you'll be familiar with the cases of George Michael and Jean Hackman. We've written several blogs in relation to those, so if anybody's interested, they would be on our website. So those are some of the issues that create a melting pot of dispute. But where do I think we are going to be in 2025? Executors and executorship claims. Now, Rhiannon is going to be talking a little later in relation to this particular topic, but I think it's fair to say that as a team, we have seen a rapid increase in executorship disputes. They are often arising as a result of disgruntled beneficiaries seeking advice and help, but equally executors who are frustrated about the inability to work with a co-executor, and issues in relation to executorships that have started but have been completely disastrous. So they turn quite quickly to us, and we're seeing an increase in that, and I think that's something also to do with the COVID period when people took things on themselves. I've talked a little bit about record disputes. Contentious probate disputes are at an all-time high, but it does ignore the fact that we do have a lot of disputes that go under the radar, and those are the ones that are dealt with at ADR, mediation and the like. We don't have those statistics, but I know from my experience in this team that we do settle a lot of disputes through those mechanisms. Digital reforms, this is a particular topic of mine, and a lot of frustration I think is shared amongst practitioners both in the contentious probate field, but also for those of you that are practicing in the private sector. The government thought it would be a good idea to streamline the probate services in 2019, but perhaps overlooked the need to get the infrastructure in place before doing so. And we then went through a period of significant disruption, delays, estates being unadministered, and my big beef, poorly trained staff and an inability for anybody to pick up the phone. Things are getting better, backlogs are decreasing, but I think it's safe to say that it hasn't been without its problems and may continue to do so. So how does this impact your clients and your risk profile? It's fair to say that financial impact upon estates and individual pockets is certainly one of the most important areas. Estates are more likely to face costly and prolonged litigation, and the rise in CFAs, that's conditional fee agreements, and DFAs, deferred fee agreements, for, in particular, 75 Act claimants, means that estates need to think very, very carefully when faced with a claimant funded by such a pricing vehicle. They need to think about how they preserve the value of the estate because the individual claimant or applicant has nothing to lose. The emotional effect, I think it's fair again to say that the emotional journey that those embarking on probate litigation cases, it can't be underestimated. Old wounds often resurface, disputes that were settled between siblings become rife, and as individuals that I've experienced seem to find that trivial points come almost an obsessive element of their instruction, chattels being my particular favourite. We've had disputes that have taken us into who owns what sofa, what are we going to do with the stamp collection, and who's got the rights to a guinea pig. These inevitably take up time, they rack up costs, and they drive their solicitor, i.e. me, to consider another career. So professional risk, a little bit more serious here. Reputation and compliance for those in the private client sector. Your files are going to be under much more scrutiny as people like me and my team will be looking through the due diligence that you've undertaken and the work that you have set out, hopefully in your file notes, to make sure that your practices and your compliance are in order. You will need to think carefully about those that approach you with a lark versus nugrus requests, and you need to think carefully about how you approach your capacity assessments and your checks and balances. You might want to ask yourself whether you indeed want to take an instruction. Is it too risky? Is it going to put stresses on your team, yourself? And I think we're all in this field know that the professional indemnity insurance and the hike in those costs are something that we need to bear in mind. Law Commission proposed reforms. I have to stress proposed reforms. These have not come into practice. They are proposed, and they were produced in a very voluminous report that came about on the 16th of May 2025, and it's the Law Commission's long-awaited report. It started life in 2017, so you can see how long it has taken. I've highlighted a few considerations. Time doesn't permit me to go into it in great detail. But they are quite important. There is a dispensing power that is being promoted that would mean that judges would have the power to recognise wills that don't meet the formal requirements but clearly express testamentary intentions, so giving the judiciary a bit of discretion there. Age reduction, a suggestion there that the minimum age for making a will would shrink from 18 to 16 in line with the right to marry. And marriage revocation on the left-hand side there would be abolished, so automatic revocation of wills would not take place. But I think electronic wills and the digital era are going to be the forefront of some of these changes. There's a suggestion that enabling electronic wills to be formally valid when using secure and reliable systems will come into play. A couple of other points that I haven't put on the slide there are a power additionally to allow a court to infer that a will was brought about due to undue influence is also being promoted, as well as certain tests for capacity taken with the 2005 Act and a code of practice. There's a lot in that report, so as I say, time doesn't permit me to go through everything in detail. But I would say that I think digital wills, video evidence and online execution are going to be things that we will need to see and consider. So what is the future for probate litigation? As I've just mentioned, I think the technological evolution will continue. I think that individuals and clients will be expecting things to be done cheaper, quicker, faster, and we will need to embrace the digital era in a way that we perhaps haven't done. And by that I'm referring to AI and all its bolt-ons. So technological evolution, I think, will also promote specialist growth. You can see the journey that my team have had over the last 10 years, and I see that the trend will continue in that direction for the next foreseeable years. ADR, again, something more for its own topic and discussion, but ADR, mediation and other forms are becoming increasingly important. And I think it's something where firms that are dealing with litigation need to readily embrace ADR in all its remits. Some processes and courts will not allow you to go through to trial unless ADR has been embraced. So that's the end of my presentation. I'm going to hand over to Ellie Clark. As I mentioned, Ellie is an associate solicitor. She's been named in the Legal 500, and she'll hate me for saying this, but she was named as a seasoned litigator who delivers exceptional results for clients in difficult circumstances. Over to you, Ellie.
Thanks, Helen. I think I'd just take the opportunity to correct that. I think seasoned was actually a typo and it meant to say young and fun litigator or something of that nature. But yes, I am, I suppose, a seasoned litigator in the probate litigation team. Helen's already introduced our team and discussed the new developments. I'll be taking you on an absolute whistle-stop tour of the key areas and issues that we deal with in the team. Hopefully this will help you as practitioners, whether that's as litigators who deal with some of this type of work or private client lawyers who see these issues in your practice when drafting wills or dealing with estates. Due to time constraints, I'm not going to be able to do anything in loads of detail, so please get in touch if you've got any questions or anything you want to discuss further, offload about clients, anything like that. Just give us a call and get in touch because we'd love to speak to you. To kick us off, I'm going to look at validity claims, specifically in respect of capacity issues. This is probably the biggest area we see in terms of inquiries, new inquiries coming in on phones. We deal with a huge amount of inquiries each week, and a large majority of those originate in some kind of capacity issues, even if that's not the claim that anyone ends up bringing forward in the end. It's where people sort of think, oh, there's a basis to challenge a will here. They see that someone has made a will. They don't think it's appropriate for some reason, and they sort of jump to capacity as normally the reason. Just to recap briefly, I'm sure everyone's aware that the test for testamentary capacity comes from the case of Banks and Goodfellow, as Helen mentioned, another quite old one, 1870 for that. And the general principles are set out there. The testator must understand the will-making nature and the effects of making a will, know the extent of their property, have an awareness of the assets being distributed, and an approximate knowledge of their value, such as that they know that they have houses, they have a value, they have money in bank accounts, and the approximate amount of money, not necessarily exact figures. They need to be able to recognise the potential beneficiaries and have a clear understanding of who might be expected to benefit from their estate, even if they then go on to make a will, leaving all of them out. And then they also should be of sound mind, of not having a disorder, poisoning affections, or preventing natural faculties. So, as Helen also mentioned, I think we're seeing an increase in this as people are living longer, developing conditions such as Alzheimer's. That's becoming more difficult and more common as an issue. There's a general presumption of capacity. So the case that normally assists us as lawyers most of the time is the case of Hawes and Burgess from 2013. The comments in this case were particularly relevant. At the time this came out, it was sort of billed in a clickbaity way as a triumph of lawyers over doctors. But basically it established the principle that courts give a lot of weight to an experienced solicitor's opinion when drafting a will, and their opinion of the testator's capacity, particularly because they've had the opportunity to meet with the testator, speak to them, assess their capacity in person, and that assessment is contemporaneous, done at the time that they made the will. So in Hawes and Burgess, the medical expert was Professor Jacoby, who's obviously amazing, now sadly retired, but absolute leader in the field. But it was the fact that his medical report, saying that the deceased didn't have capacity, was done later on the basis of medical records rather than a contemporaneous assessment. And it's that difference in the timing of the assessment and the nature of the assessment that led to the conclusion that the deceased in that case did have capacity at the time they made the will, although the will was then found to be invalid due to lack of knowledge and approval. So in general, courts are cautious about post-event medical evidence, particularly from experts who weren't able to examine the testator at the time. In terms of practical considerations, just put a few points on there in relation to things to look for. I put identify mental disorders, obviously easier said than done. But any sort of major red flags, unusual behaviour, family members flagging up any unusual behaviour. And then that relates to the next point, which is reviewing past decisions. So looking at any previous wills, any previous indications they've given of behaviour, if they've previously been on excellent terms with family members and then suddenly they're all written out and everything's left to a neighbour or something along those lines. That kind of thing would be obviously a red flag, something to look into in more detail. Support independence. I think Helen mentioned particularly tricky wills, risky wills, where someone has diminished capacity and you know that there's an issue in terms of their capacity and their potential ability to make a will. I was involved in one particular case where this decision was taken to have a medical report prepared by an old age psychiatrist. It was exactly what we would hope to see. The medical report was prepared and the expert concluded that the testator could potentially have capacity if supported to make the decisions and supported to work out what to do with her estate. And they gave several recommendations, including the time of day to take instructions, who needed to be present, who needed to be sort of running through various things to check that she still definitely understood at the time that she made the will. And it was a very helpful report. And then, unfortunately, the will draftsman did absolutely none of those things and sent out a will questionnaire, got the will questionnaire back, filled in by whoever, we don't know, drafted the will on those terms, and then the deceased duly executed it. The will was rightly challenged and found to be invalid. So when I say support independence, absolutely there are people in certain circumstances that with diminished capacity that can make a will, but if those recommendations are given, obviously then check that they are then sort of adhered to. And that's something that we see when we are looking at challenging wills. Sometimes there will be a report to say, oh, this person could potentially have capacity, or how could have capacity under certain circumstances, and that is really something that we look into further when looking at a will challenge. So then the final point would be to document absolutely everything. Everyone sort of involved in will drafting knows this to be the case, but I think particularly with some older wills, we often see very brief notes. This is sort of things maybe to look for if you're someone who is a private client lawyer drafting wills, or if you're challenging wills. We often see sort of just very briefly something like, oh, no concerns about capacity, or completely fine, no issues in relation to memory, but no detail about how that conclusion was reached. What's really useful from our point of view, if we're looking at normally defending a will, or potentially the absence of that if we're bringing a claim, is a bit more detail, particularly to potentially jog your memory later if you're giving evidence about the will drafting process. So if someone greeted you appropriately, knew why you were there when you were attended for an appointment, if they were able to chat appropriately about the weather, talk about current events, what they did at the weekend, sunny bank holiday, that kind of thing, all that's really useful. And that might well have gone towards you saying, no issues in relation to capacity. But if it's not documented, it's very hard to tell that that's the reason and the thinking that's gone behind that, particularly as professionals. When you've got a lot of experience in this area, you might well reach that conclusion as to capacity very, very quickly. But it's actually documenting that as well is something that certainly in defending claims we find extremely helpful. Also, document what they did as well as what they say. So if they made a cup of tea or something along those lines, the process is required to be able to do that, and also know that it's appropriate to offer you a cup of tea. That kind of thing is all really helpful, because often what we will see is a letter of claim setting out a situation where they would paint a picture of the testator as someone who is really not capable of doing pretty much anything. They will say, they didn't understand where they were, they didn't understand who anyone was, they weren't able to sort of look after themselves or anything like that. And if you've got a file note, even if it's not directly a sort of a capacity assessment, to say they greeted me, they said they were really pleased to see me because they want to change their will, they made me a cup of tea, that kind of thing, then that just goes to paint the picture to show that you even if there's no actual assessment, there's sort of consideration of the capacity there. Another point that we see a lot in will files is if the testator's given information about their estate, it'll often just say it's not a taxable estate, and no real other information there. As we went through the criteria before, looking at whether they're aware of the extent of their estate is one of the factors in relation to whether they've got testamentary capacity. So even if it's just a brief note, that's really helpful to have there, although potentially when you're drafting the will, whether it's taxable or not is something that's a consideration, but more information is useful. Again, also who might hope to benefit from their estate, even if it's someone that's immediately dismissed, such as a son that's been estranged for 30 years or something like that. Having that detail in the file note as well as in potentially a side note to the will is really helpful, because I've been involved in cases and also seen cases in the team where the provenance of a side note that goes alongside the will has been questioned. And they say, my sister wrote that note about me being awful, and that's why I've been excluded from the will. If there's also evidence in the will file, that's really helpful. So I think commonly we have seen it where people have just been told, if you're excluding that person, go away, write a note in your own handwriting, etc., etc. So it's in your own words, but it's useful to also have it in the will file. I mean, that is very much the tip of the iceberg in terms of things that we deal with in relation to capacity and validity claims. But there's quite a lot to get through. Again, anything else, just raise it with us, either come and see us or give us a call. Now I'm going to move on to our sort of probably second largest type of inquiries, although these are often people ringing just knowing that they want to challenge a will, not necessarily knowing it's an Inheritance Act claim at this stage. Inheritance Act claims. There's a picture of Monty Python and the Holy Grail there, which, because it came out in 1975 at the same time as the Inheritance Act, I did have loads of pictures, but unfortunately, due to probably reasons of taste and also whether we have the rights to them, they've all been taken out, apart from that one. So basically, as I'm sure you are all aware, there's various categories of people who can challenge a will. This is when a will is valid or there's an intestacy situation, but someone has been left out and hasn't been reasonably provided for. The time limit for making these types of claims is something that we commonly say to pretty much everyone that inquires about these, is 6 months from the date of the grant of probate. Something to flag up is that I think certainly in recent years as a team we've seen more willingness in the court to allow claims out of time or after that 6 month time period. It is something to consider in more detail, particularly from a cost point of view, because obviously you're putting more costs into a claim. You don't know if you're going to have the right to bring the claim yet. But certainly we've seen more willingness to allow those claims. We've brought several successful claims out of time in probably the last sort of 18 months or so. And so certainly if you are getting inquiries of that nature, wouldn't think that that was a bar to bringing the claim. It's certainly something that's worth looking into further, but we'd suggest speaking to us or someone else in relation to taking specialist advice on that, because of the cost risk really of putting that extra money into it when you've not got the right to bring the claim. Just going through briefly the categories of claimants under the Inheritance Act: spouse or civil partner, cohabitants, partners who live with the deceased for more than 2 years immediately preceding their death as husband and wife, children, anyone treated as a child, so that's biological, adopted children, general children of the family, can include stepchildren, can also include sort of grandchildren if they were brought up by grandparents, that kind of thing. And dependents, so anyone financially maintained by the deceased. That maintenance can be sort of regular cash payments. It can be support in terms of sort of paying for education or something of that nature, or allowing people to live in a house without paying rent is one that we see quite commonly in terms of maintenance. Just looking at the different provision, for spouse and civil partners is normally seen as the sort of highest claimant, or the one that's given sort of the biggest share of the estate, and that will be spouse or civil partners. It's not limited to what they need for their maintenance. It's what would be reasonable under the circumstances, and for that the court look at a divorce comparison, often called a divorce cross-check. So they will look at what would have happened if the deceased and the claimant had divorced at the time that the deceased passed away, so the marriage had ended in divorce rather than death. That can often mean a 50-50 split of the parties' sort of joint assets or the marital assets. And specific considerations taken of the duration of the marriage, and that would also include any periods of cohabitation beforehand. So if they've lived together for 10 years and married, you know, relatively recently before the person passed away, as is quite often the case, I think, in things that we see when people want to sort of formalise their affairs before they pass away, then that period of cohabitation is taken into account as well. They'll also look at the contribution to the family in the same way that they would in divorce cases. So that's not just financial contribution, that would be sort of looking after children or being a homemaker or something, so that potentially the other party, often the man, can go out and earn money. We see that quite a lot, particularly with sort of second marriages, that the children from the first marriage find that a very difficult concept to deal with, because they will feel that potentially their dad has provided the money, and maybe the other partner hasn't really contributed very much, but that is their contribution in terms of the homemaking or looking after children is taken into consideration as well. In terms of other applicants, this is limited to what they need for their maintenance, unlike the spousal claims. Unfortunately and unhelpfully, what's reasonable provision isn't really defined. It's more than subsistence level, but it's not a lavish lifestyle. And these, not really much more I can say other than the cases are very much decided on their own facts. The recent case, one of the cases that really defines this is the recent case of Jenna Howe, whose father was a pirate radio legend, Roger Howe. This made it into the Daily Mail for all regular readers, so you might already be familiar with it. And she received £125,000 of his £1.4 million estate in her successful Inheritance Act claim. And this was supposed to be to pay her debts, which is standard reasonable provision in my experience, to fund essential purchases such as a car and white goods, also pretty standard, not really that controversial, to cover an income shortfall for 10 years, also relatively standard reasonable provision, and to provide for her health needs, including therapy and necessary breast implants to increase her confidence. That's the bit that I would find less usual, and I think if I was asked in isolation whether breast implants were reasonable provision under the Inheritance Act, I'd probably say no. So I think that's an excellent illustration of how these cases are really decided on their individual facts, and it's very difficult to tell what sort of objectively would be reasonable provision. It really does depend on the facts of the individual case and their situations. Other considerations in Inheritance Act claims, the main one that we would look at first is the party's financial position, because the remedy is whatever provision would be reasonable. So if they haven't really got a financial need, then then it doesn't really, not that it doesn't matter about the other factors, but it's you know, that's the first consideration, is whether they have a need for maintenance from the estate. We'd also look at whether they've got any physical or mental disabilities. That's the area where sort of significant evidence is really useful. Both if we're bringing a claim, we'd want to provide as much evidence as possible, and if we were trying to defend a claim, we would be asking for significant evidence of any physical and mental disabilities. The court will look at the size and nature of the deceased estate. The claim would still be limited to what is needed for maintenance, but the size of the estate is relevant, particularly if there are additional applicants, and the deceased obligations, responsibilities towards the claimant, any other beneficiaries, and then any other factor, including the conduct of the applicant or any other party involved. Just a word of warning about conduct. Our clients certainly, or clients that we deal with on the whole, would like to raise a lot of conduct issues. Probably pages and pages of conduct issues, because they've been dealing with these claims for a long time, potentially want to have their say, they want to get their sort of account of what happened out there. In my experience, conduct issues, the relevant conduct issues are normally really very, very extreme. On the whole, we would try and reduce any conduct issues to really something very minimal, just because normally, in my experience, the court is not really that concerned, unless it's really quite extreme behaviour. And the back and forth of dealing with sort of conduct issues or trying to raise those just tends to run up costs, and also potentially mean the parties get very entrenched in their positions, and it makes settlement a lot harder. So that has been an absolute whistle-stop tour of claimant side Inheritance Act claims. In terms of defending them, just a quick point in that it can be quite difficult to look at the different roles that people have. So in terms of the defendants would normally be the personal representatives or the executors, and also the beneficiaries of the estate, and they've got quite separate roles. So personal representatives should normally remain neutral. Their primary role is to provide estate information to the court and to the other parties, and they're not expected to actively defend claims. I say should remain neutral. That's if they want to get their costs paid out of the estate. If they're happy to pay the costs on a personal basis, then they can do whatever they like. But if they want to have their costs paid out of the estate, they should remain neutral. And for that reason, we would normally recommend separate representation, because then it's very obvious, it's very easy to show that they've got separate representation. Their costs are one solicitor, and then the beneficiary's costs, who are the active defendant in relation to the claim, are another solicitor. And so in all cases, but very, very, very small estates, that's normally what we would recommend, and we do tend to work with other firms where there's that kind of conflict to move people around, so that they can get that separate representation. And so that's all from me. Sorry, it's been quite brief, but anything else that you want to pick up, please just get in touch, and I will hand over to Rhiannon, who will deal with executor issues.
Thank you very much, Ellie. So, as Ellie said, I'm going to be dealing with, thank you, this will help, with executive issues today, mainly covering how to deal with managing conflict and misconduct, which I'm sure you all deal with on a daily basis. Briefly, my background in this area, I came to contentious probate from a purely non-contentious private client background. So when I initially qualified, I was dealing with estate administration, drafting wills, powers of attorney, that sort of thing. And then I moved into a mixed practice, and for the last 5 or so years, I've been dealing with probate litigation only. So I appreciate completely where you are in terms of, you can see these issues with executors from a very early stage, from the first time they come in, from the first time that you see a copy of the will. There's all sorts of red flags that you will be able to spot at an early stage. So hopefully this is going to help what you do next, what you're looking for, those sorts of things. Oh, if I could get this to go the right way. Right, so firstly, the different types of executors. So the good, the bad and the ugly. Problematic executors tend to fall into, in my experience, 3 different types of categories. Firstly, you've got the good. This is the sort of executor that has the very best of intentions, really wants to do a good job for the deceased and for the beneficiaries, but they have absolutely no clue what they're doing. They can often be the most dangerous sort of executors to deal with, because they will go headlong into administering the estate, trying to do the best job possible, but they are very confidently taking incorrect steps and sometimes get themselves in a bit of a knot that you then have to try and unravel. Secondly, you've got the bad. These tend to have even less of an idea. They take absolutely no steps to administer the estate. They bury their head in the sand, and some seem to have quite a genuine belief that if they do nothing, they ignore all correspondence, and they just sort of sit there, that nothing will happen and that there will be no consequences to that. Lastly, you've got the ugly. They are the ones who are intentionally causing problems. So they are intentionally not taking a neutral stance, favouring perhaps one beneficiary or one class of beneficiaries over another. You will find that their position often becomes quite entrenched if a claim is intimated against the estate, or if any criticism is comes across their inbox. They will often use delaying tactics. They will refuse to account to the beneficiaries. They normally take a much more combative approach than the other 2 classes. The other 2 classes can, in some cases, be a bit easier to deal with, in that when the wrongdoing is addressed, they are more open to discussing it and hopefully finding a resolution. So when you're considering problematic executors and you're having these initial people coming into an estate administration process, you want to be considering what the executor's duties are, so we can decide whether or not they've breached them. There are both statutory and fiduciary duties for executors. The statutory duties are set out in the Administration of Estates Act and in the Trustee Act. Broadly, the duties are to collect in the real and personal estate of the deceased and to administer the estate according to the law, that being under the terms of the will, or if there isn't a will, under the rules of intestacy. When required to do so by the court, or indeed by the beneficiaries on demand if proceedings haven't been issued, to exhibit a full inventory and account of the estate assets and the estate administration to date, and when required to do so by the court, or indeed by the beneficiaries at an earlier stage, to deliver up the estate documents, so a grant of probate or letters of administration, depending on what sort of estate that you're dealing with. The fiduciary duties of executors are to act with reasonable care and skill and in good faith. Acting in good faith is fairly easy to spot if they're not. Excuse me. But acting with reasonable care and skill, that is a subjective standard. So if you have got a professional executor, or an executor who isn't acting in their professional capacity, but is, for example, a Myerson Probate Solicitor or something like that, they will be held to the reasonable standard of their profession and their training. If you've got a lay executor, then the standard is different. They've got a duty not to profit from their position as executor. So you're looking there for things like if somebody has an interest in a property that perhaps is shared by the deceased and they're taking certain steps to conserve the property or something like that goes against the interests of the beneficiaries. Again, that comes into avoiding conflicts. Normally, there'll be a conflict between the beneficiary and the executor that you're looking for. And again, similar to the statutory duty, there's a fiduciary duty to keep accurate accounts. Now, this is something that certainly when I was dealing with non-contentious private client, I sometimes found a bit difficult, because if you don't keep an account basically from the start all the way through, and then you've got a beneficiary that demands a set of estate accounts, you're then trying to prepare a set of interim accounts, which can be quite difficult when you weren't planning to do it until the end. So it's always best practice, if possible, and I know there's programmes that do it now that weren't there when I first qualified, where you can feed figures in from the outset and hopefully produce a set of estate accounts quite easily if you are in a situation where a beneficiary has asked for a copy. So when you're looking at executors' duties and you're considering whether or not they've been breached, there are certain red flags. Some are obvious, some aren't as obvious. The typical one will be not communicating. So often you'll get clients that come to you to say, this person has not been communicating. I've tried to send them emails, I've tried to send them texts, I've turned up at their house. They'll often try and not communicate with you once you're instructed. Often being unnecessarily cagey. You'll get constant reasons why progress hasn't been made. Sometimes there are genuine reasons, so you'll find perhaps ill health or family bereavement or something like that, but you get the whole gamut of excuses to my budgie's got the flu and things like that, so you do get all sorts. So it's important to weigh that and see whether or not it's a reasonable reason. You'll often get a refusal to take legal advice with no sort of real reason behind that. When you've got two executors and an executor comes to you to say executor B is causing problems, you will often find that executor has unilaterally taken the lead and hasn't consulted with their co-executors, has got headlong into trying to administer the estate. Sometimes you'll get executors that quite genuinely believe, or sometimes don't genuinely believe, but that is the point they're trying to make, that they are following the wishes of the deceased. Often these wishes of the deceased aren't written down anywhere, so they're not in the will, they're not in the letter of wishes, but they will be, to give them the benefit of the doubt, labouring under the misapprehension that the deceased wanted them to act in a certain way, and that they are able to do that because the deceased told them that that's what they wanted. So when to take action, I mean, as with all sorts of litigation, as soon as you possibly can is always going to be better. A few reasons for that. You've got a better chance of reaching a resolution, hopefully without the need to resort to court action. Hopefully it means costs will then be lower for the client, and equally with these sorts of claims you've got a real danger that assets could be dissipated incorrectly. So the earlier you can take action, the earlier you can take steps to stop that from happening. Some issues are quite obvious early on, so you may have an executor appointed in the will who is inherently inappropriate, so they may have a fraud conviction or something like that, or it may be that they no longer have mental capacity, so perhaps someone was appointed in a will 10 years ago and they've now got a diagnosis of dementia and don't have capacity. You can normally deal with that fairly easily with a separate approach, but those are the sorts of issues you can spot really early on. Some issues only arise at a very late stage, so sometimes the estate will be being administered, everything's hunky-dory, and then your client thinks they're going to get a cheque for $250,000 and they get a cheque for £5, and then they come to you panicking. So you will get people coming to you at different stages. So what are your immediate considerations when you're in those situations? Number one is always going to be to secure the assets. So the easiest way of doing this is to request an undertaking. That's, I say easy, it's normally like getting blood out of a stone with some people. If you can get an undertaking with the executor that they will stop administering the estate if that's what you need, so won't put a property on the market, or will just keep the assets safe, won't dissipate them if they are all in an account, for example, then that's the best sort of outcome. Often you will either find yourself hitting a brick wall and you can't get an agreement or can't get a response, in which case you may have to consider applying for an injunction. This injunction application will run sort of alongside any court action that you're taking for removing an executor, but it will happen a lot quicker. So normally if you are making an application for an injunction, you'll get a hearing that same week, and you'll get some sort of, hopefully, interim injunction. You will likely then have to return to court a few weeks later to make that permanent for the rest of the estate administration if that's necessary. And as always, you've got to look at costs from the outset. So here I'm talking more about the initial cost to your client, and to consider the proportionality of that. So if you've got a really small estate, it can often be quite frustrating to clients to hear that in reality, even though there may be some obvious wrongdoing, the cost of making that application may mean that it's simply not proportionate, or it may be that it is, and you want to look at different funding options. We offer CFAs and deferred fee agreements for clients, so we do have quite a lot of options if that is anything that you're struggling with clients funding their claims. So you've got past that stage, you've decided you're wanting to take on the client and take the initial steps. There is no set pre-action protocol for executor removal, but it is important that you take some set-up steps, as we call them, to establish a paper trail at an early stage. Sometimes a client will not want you to do this or not quite understand why you're doing this when they come to you having said, well, I've been writing to this person myself for 1 year and I've got 10,000 letters that I've sent them and they've not responded, or they've responded saying get lost. It's important that where possible we do still write to them, so that we've got that paper trail that we can show the court that we're acting reasonably. It's really important, especially when you've got a lay executor, that in that initial correspondence from a solicitor, you're setting out in detail and in a simple way exactly what their duties are, exactly what we or our client believes they have done to breach those duties, and hopefully, if there is a possibility, what could be done to remedy those breaches. So you can set that out and give a time limit, perhaps 14 days, and ask them if they will remedy the breaches by that time, or give some sort of assurance that they are going to. That's always the best way of doing it, if they can agree at that stage. It may be that they don't, but hopefully they do. If they don't, you've got that as a really good piece of evidence when you're bringing your claim together. It's also helpful to consider an independent administrator at this early stage, and perhaps include that in your initial letter if it's something that your client's willing to consider. At this stage, if you are appointing an independent administrator, then the executor that you're having problems with will need to agree to that. But you will quite often find, if you suggest an independent administrator who is going to be completely neutral, that will be something that they are willing to consider, particularly where you've got executors that had the best intentions, were acting in what they thought was the best interest of the estate. Once it's explained to them that they are in fact acting incorrectly, you might find that they are quite open to doing that. Also, even executors that weren't acting with the best of intentions may just want to wash their hands of it by this stage. So it can quite often be an attractive option. So it's always something worth exploring. So that hasn't worked, and you're now wanting to issue court proceedings. So, as I said previously, there's two legal bases under which you can remove an executor. Number one is Section 50 of the Administration of Justice Act. Number two is Section 116 of the Senior Courts Act. It did used to traditionally be that Section 50 was used post-grant and Section 116 was used pre-grant. That is still the case, but the general consensus, certainly from counsel that we've worked with, tends to be to make the application under both sections. So you would need to refer to both sections in the claim form. You will need to prepare a witness statement. Usually the witness statement will be from your client. You want to be really succinct here if you possibly can. The client, similar to what Ellie was saying, when you've got different probate claims, clients will want to go to town on the conduct. They will want to say how terrible this person is and how they've done all these awful things. Quite often, as Helen said, because there was an argument in the playground 60 years ago, and you need to really rein them in and avoid using any inflammatory language or anything like that, especially with executor removal claims, because they are really more about the breach of the legal duty, and you really don't need any sort of personal commentary really with that. You want to reference all the pre-action steps. So this is where you can bring in the pre-action steps that your client may have taken before they have instructed you. So if they have sent emails, texts, etc., it's helpful to exhibit them, and perhaps include a timeline to say they have been emailing since X date, we were instructed, we sent this letter, here is the letter, and we've heard nothing, or they've come back to us and refused to cooperate. You will want to include all that evidence in your claim form. Right, so another consideration when you are preparing the papers to issue proceedings is you're going to want to consider, if you haven't already, who you and your client want to appoint as a replacement administrator. The court will make the final decision on this, but you do want to put somebody forward in your claim. Whoever you put forward is going to need to be supported by a certificate of suitability, so you want to have that in the back of your mind when you're discussing different options with your client. Quite often your client's initial sort of review or reaction will be, well, it's going to be me, I'm going to be the replacement, particularly where you're in a situation where you're being instructed by a co-executor and it's their co-executor who they're wanting to remove. This can sometimes be fine, but it's important to dig a bit deeper with your client, because sometimes it's not wise depending on the circumstances. So it's likely the relationship wasn't great anyway. It's not going to have been improved at all by issuing court proceedings, and it may be that they're simply going to be jumping out of the frying pan into the fire if they do that. So it's important to have that conversation. You may wish to look for an independent administrator, so an independent professional who can be named and can deal with the estate administration. I would always recommend looking for a step qualified solicitor here, so you can make sure that you're dealing with somebody that has the experience and knowledge to be able to deal with the estate properly. You might want to think about what sort of estate you've got. So if you've got an agricultural estate, or if you've got an estate with complex tax issues, or if you've got a really complex estate that's been confounded by steps that the executor's taken, you want to make sure that you're dealing with somebody who's able to unwind that and put the estate on the proper footing. You may want to think about a trust corporation. Myerson have a trust corporation, which is aptly named Myerson Trust Corporation. The advantages of using a trust corporation as opposed to a single independent administrator is that you've got a team of people who are able to administer the estate, so a team of fee earners who are able to deal with the day-to-day running. So especially when you've got a bit of a tricky estate where you've had to issue proceedings already, it's likely you're going to get a lot of questions, a lot of requests for updates, and it means there's always going to be somebody there in an independent administrator's absence to be able to provide an update and make sure things continue to move. So you've issued proceedings and you are now serving. It's always helpful, if possible, if you can send a copy of the issued proceedings, so the claim form and the witness statement and evidence, to the executor at an early stage for information only. The advantage of this is they will know that you are taking this seriously. It may be that when you initially say, if you don't get back to us within X time limit, then we're going to issue proceedings, and they think, no, that's not going to happen. It will show you're taking it seriously. It will give them that last push, hopefully, to take those remedial steps, if indeed that is something that would be helpful. When you're doing that, you want to make sure that you make it really, really clear that you are serving them the proceeding, or not serving, don't use the word serving, that you are sending them for information only. Put that in bold and underline it. You don't want to find yourself in a situation where you've inadvertently served proceedings and then you've started time limits going. If you are having to serve, then you've got 4 months to do so. You want to just make sure you double and triple check all service requirements when you're doing this, because there can be punitive measures if you don't. But again, this is all things that we can assist with if you have any difficulties. Once proceedings are served, the next stage will likely be that the court will list a case management conference. That will be your first formal court appearance. It's normally just a directions hearing. They'll set the next steps. It's having spoken to different colleagues, it seems to be that the court really does do quite different things in terms of which judge you get and how they want to run these sorts of cases. Some people have experienced judges listing just for a normal hearing where they will hear evidence, or you will have people, judges, asking for an early neutral evaluation, which is sort of like a judge-led mediation. So they've got quite a wide discretion in terms of what they do in this regard. Costs. So costs could be an entire talk in itself. So this is just going to be a brief overview of key points. From the start, I would say manage client expectations about costs, especially when you're acting for a claimant, because invariably the claimant's costs are going to be higher because they're the ones that have had to take those initial setup steps. They're the ones that have had to issue proceedings. So there has been more time spent on the work for the claimant than the defendant, and they can often have a bit of a sense of injustice that they were in the right, so to speak, and their costs are higher. When you've got an order for executor removal, then your next thought is going to be who's going to pay the costs. It did tend to be that if you were making an application under Section 116 and there were what's called special circumstances, that you may be more likely to have an order that the estate covers the costs, but this is by no means nailed on. If you do get an order for costs, then it's likely to be if they're not agreed between the party, you'll need to apply to have an assessment by the court. So if you and the other side can't agree what the costs are going to be, you need to apply for an assessment, and that needs to be within 3 months of the order. And again, that's something to really look carefully at, because there's some quite punitive measures in place if you miss that deadline. Again, this is where you want to look at funding options from the outset to see where you are with clients. Can they afford the initial outlay of costs? Can they pay privately, or do they want to defer their fees to the end? And this is something we can certainly assist with if you've got clients that are wanting different funding options. Once you've got the order, there's a few other general things to think about. Will very much depend on the circumstances of the removal and who you have got appointed. But you will maybe be wanting to look for the delivery up of the key documents. One of the problems with the executor may be that they wouldn't provide a copy of the will or the original will. You may want to look at whether the grant has been properly obtained, have the assets been declared correctly, particularly where you've got taxable estates. How we can help at Myerson, hopefully you have, hopefully especially the people in the room have got the feeling that we're a friendly bunch, which we certainly are. So any initial discussions are more than welcome. If you spot any of those red flags, and if you're thinking that action might need to be taken and you're not quite sure, feel free to pick up the phone. We're always happy to talk. We're happy to assist with any application for executor removal where your firm or your client are going to be appointed. We can do that discreet piece of work, and then you can continue with the estate administration, which will hopefully then be on an easier footing. Any new inquiries that you get that you want a bit of a steer on, we are happy to help. And as I said before, we've got Myerson Trust Corporation if you are thinking that you want to appoint a completely neutral party. Now, we should have our emails on the next slide. If you've got any questions at all, please don't hesitate to be in touch. Thank you so much for coming today, everybody. It's been brilliant to see the people that we've got in person, and thank you for everybody who has attended online. If you have any questions at all, then our email address, I think, is on the slide, which is being shown now. Pick up the phone, drop us an email, anything like that. Anybody here in person, feel free to speak to us after the session. We've got plenty more pastries to get through, and anybody online who has put any questions in the question box, then we will get back to you and hopefully can point you in the right direction. But thank you very much, everybody, for coming.